want to start by asking the audience a quick question. Who here has ever asked a lawyer what they felt was a fairly straightforward question, and in response they get, oh, well, the law is unsettled in this area, or it depends, or something really squishy? Yeah. All right. Me too. So I'm sorry to record your frustration with lawyers is probably going to continue throughout today, because in the cyberbullying context in these cases, the law is unsettled. A lot of it depends on the facts, they're very fact dependent. But I will tell you where we are as a legal community and hopefully where we're going. So we have some idea of what the future holds. So the first thing to point out is that these anti-bullying statutes now are everywhere. Every state but Montana has some form, in some form or another, some law that prohibits cyberbullying or electronic harassment in schools. And all of those states require the schools to adopt an anti-bullying policy. So these are relatively new. Most, if not all of them, have come about in the last 10 years or so. And I want to clarify that these anti-bullying laws that I'm talking about here that require school rules to implement an anti-bullying policy are different from the criminal statutes that punish different forms of harassment. So every state has some type of criminal harassment statute. About a third of states prohibit electronic harassment specifically, including Washington. So we have both. We have school rules and then we have criminal statutes, and they live in somewhat different worlds. They vary quite a bit from state to state in terms of what cyberbullying or electronic harassment means. As Ellen touched on, there are many, many different forms of cyberbullying. It's called different things in different contexts, and the form of it can vary from context to context. So you might have a video that's posted on YouTube that's taken the wrong way or posted maliciously. You might have a mean Facebook post, a mean tweet, a mean text or email that's recirculated. So a lot of these states are wording their anti-bullying policies very broadly to try to capture all these different forms of cyberbullying. Some states are fairly specific in what they prohibit, like Washington's is fairly detailed in, and we'll go over that statute in a second, fairly detailed in what's prohibited. Other states are quite broad and have come under some criticism, some from free speech groups like the ACLU, for example, who say that it's inadvertently infringing on constitutionally protected free speech, and that could be a problem. Lastly, in part because these statutes are so new and these rules are so fresh, and we have no U.S. Supreme Court opinion governing the permissible limits of a cyberbullying law and what can be prohibited under the Constitution, these cases are terribly fact specific. The lower courts don't have a whole lot of guidance as yet from Supreme Courts as to when a punishment is permissible for cyberbullying. So facts really, really matter. And specifically going to the impact of the cyberbullying is what the courts are most concerned with. So this is the Washington law on cyberbullying in schools. Again, this is the school rule law. This is the statute that was passed that mandates the anti-bullying policy. And as you can see, it has a few different alternative elements. It could mean a few different things. The first one physically harms a student or damages student property. It's pretty no-brainer. This has been criminalized for a long time under assault and battery and malicious mischief statutes. So that makes sense that it's in there. These next three are newer concepts. B and D come from a U.S. Supreme Court opinion called Tinker v. Des Moines that says that schools can regulate speech, student speech, in these two contexts. C comes from, it's language from case law relating to Civil Rights Act cases that talk about creating a hostile environment. So really this statute has sort of a dual purpose. The schools are clearly interested in protecting kids from harm, but they also want to protect themselves because they can come under fire from parents and students if they allow cyberbullying to occur unchecked, and it creates a hostile environment for the child, especially if it relates to gender or race or other protected classes. So, of course, the question when a statute or a policy or a rule is put into place is, does this thing have teeth? Is this ever enforced? And if so, what does it look like? Well, you can ask the kids at McClure Middle School here in Seattle whether it has teeth. This is happened about 4 years ago, and there was a situation where you had a Facebook page that was created targeting a single student, and other kids in the school were made aware of it. It was circulated, and on Facebook, if you're not aware, you can like a page and you become a fan of that page, and a bunch of kids decided to go ahead and like this page. This page was only up for about 24 hours, but the administration found out about it. They found out who had liked the page, and in McClure they have a zero tolerance policy for bullying, and 28 kids were suspended. And the range of suspension was 2 to 8 days. So if you liked the page and had no other involvement, it was 2 days. If you did more, had more involvement, and the punishment was more severe. So I mentioned these statutes vary quite a bit, and I wanted to give a couple examples outside of Washington State of what these statutes look like. So this, the first example here is from Arkansas, and it in part prohibits ridicule of a student or school employee that, quote, results in inability of students or educational staff to focus on learning. Indiana goes a little bit further, prohibits, and this is a criminal statute, prohibits using a computer to communicate with intent to annoy or alarm. So some legal commentators have been raising some eyebrows about this, as you can imagine. In Arkansas, one legal commentator raised this hypothetical. Let's say you have a very bright student in Little Rock High School, and there's a science teacher who decides to start teaching a unit on creationism, which actually still happens in Little Rock, parts of Little Rock, if you weren't aware. And the student sees this, and he decides to post on Facebook, hey, this guy is crazy. He's teaching creationism in school. This is in violation of federal law prohibiting establishment of religion in schools. And he goes and he outlines all the problems with creationism and why it doesn't make sense, and sends it to all his friends. All his friends see it. Everyone in the class sees it. And the next day they come in and they start giving the teacher problems, and they stop paying attention to the lesson. Let's say the teacher becomes upset by this, maybe offended. The teacher has grounds under the Arkansas statute to have this kid suspended. So that we have a potential constitutional problem there. Indiana goes even further. So I don't know if anyone's ever posted a negative review on Yelp or posted a negative comment on a news story, but you better not do it in Indiana. So the point I'm making is not that these have an invalid purpose. Of course the purpose is valid. They're trying to keep kids from getting hurt. The danger is that some court is likely to find, especially the Indiana statute, some court is likely to find this to be overbroad, that they infringe on free speech and unconstitutional. And the problem is this sets the whole effort back, because if a statute is deemed unconstitutional, states have to scrap it, they have to start from scratch, pass a new one, and meanwhile kids are getting mixed messages about what they can do and what's valid and what's not, and what's constitutional and what's not, aside from the First Amendment concerns themselves. So this is the law that we have regarding freedom of speech in schools. So as I mentioned earlier, this case Tinker v. Des Moines is more or less what we have to go on. This is a case that involved a group of kids wearing black armbands to school during the midst of the Vietnam War, and they were punished for doing so. School said, oh wait a second, schools are, the court said schools are special places. They're not, students don't exactly have the same rights as an adult would in public, but they do have some rights. And if a student walks into school and wants to express themselves politically, in this case, they're generally free to do that. A more general concept was articulated in this case, RAV v. St. Paul, and this has been articulated over and over again. Essentially, the government can't protect against hurt feelings. We're free, essentially, according to the Supreme Court, to offend each other. And the way to remedy hate in the Supreme Court's view is not by suppressing speech, but to engage in dialogue that hopefully over time will diminish narrow-mindedness and negativity. But we don't want to squash that dialogue because that's antithetical to who we are. There are some limits. As I mentioned, so school is a special place. Students don't have quite the rights that adults would in a public setting. Tinker also held, very importantly, that the regulation in school is generally permissible when the speech substantially, I meant to say, disrupts the orderly operation of the school. So in the armband example, they said, well, this created some fuss, but really school was allowed to go on. These students were allowed to, or should be allowed to continue with this kind of thing. There are a few, since Tinker, there are a few other examples that have come out of the Supreme Court. Bethel v. Frazier is one of them, which prohibited lewd speech. There was a student making a lewd speech in a student government nomination, and the Supreme Court said a school can prohibit that. There are a few other examples of speech in a school-sponsored newspaper. The court said that the court can regulate that. The school can regulate that. And advocacy of illegal conduct, school can regulate that as well. But this is basically what we have. This is the extent of it. Those 4 cases I just mentioned are the extent of what lower courts have to go on. And the only one that really matters in the cyberbullying context, in which cited over and over again in these cyberbullying cases, is the Tinker standard. So courts will look at, very specifically, the impact of the cyberbullying, or the bullying, and conclude whether the punishment is permissible based on whether there's a substantial disruption. Now, the Tinker didn't talk about bullying, it involved political speech. None of these cases talk about harassment. So a lot of people have argued that we're using cases that don't necessarily apply to this context, and it's sort of a mismatch. Courts are doing the best they can. This is the guidance they have to go on. They're split on whether substantial disruption can occur when only a single student is targeted and the effect is strictly on that student, or whether it needs to be a broader disruption. So the last thing I'll say, and then I'll turn it over, is because lower courts have very little legal guidance on how to come out in these cases, you find that the evidence and the facts, the context of the case are super important. The courts will look for any evidence of impact they can find to justify that punishment. A lot of these cases are really egregious, involve really horrible behavior, and you get the feeling from these opinions that courts want to do something about it, but they can't under the Supreme Court law unless they get some evidence of impact. So they're always looking for impact. In this case that I've cited here is a good example. This was a YouTube video. A group of girls, 13-year-old girls, got together, posted this YouTube video bashing another 13-year-old, and she complained to school administrators, and JC, the girl who posted the video, was suspended, and she challenged her suspension in court. And the court looked at all the circumstances. They said, well, the victim was embarrassed. She had hurt feelings. That's undeniable. There was a certain morning where she didn't really feel like going to class. But she wasn't afraid of getting hurt. There was no threat to her property. I don't really see a substantial impact here. We don't see a substantial disruption in the educational environment. So the punishment was overturned. It was found to be an unconstitutional breach of free speech. So the lesson from this case is if you're a victim of cyberbullying, if you're talking to a victim of cyberbullying, or if you're accused of cyberbullying, get all the evidence you possibly can. So take screenshots. If you're going to a counselor or school administrator, document those visits. Do everything you possibly can. Additionally, if it's happening at school, there's a question as to what extent schools can regulate off-campus speech. If any aspect of it is happening at school, take video of it, record it. Get that all together because that's going to help determine the impact. And these cases